Alex here with part 66 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I am not in the middle of this right now. My case is completely and totally over. It's closed, it cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. This is one of the points in the My Docket series where I actually have a lot of memory, recollection, you could say, about this part of my litigation with my ex. And I think towards the beginning of the series, it was pretty much the same way. You guys probably got a lot of details about my mindset, what I was going through, and then it got lesser and lesser, especially during the portions of the My Docket series where I'm filing papers like one after the other with hardly any time in between. But this is a filing that I very vividly remember, and that is because it involved not only the end of one of the midnight exchanges, but also the beginning of getting my son into a great school, at least comparatively speaking. The Washoe County School District was, and I think still is, one of the worst in the country, I guess. It's embarrassing to have to say that, but the judge actually, this goes to a hearing, and the judge actually states from the bench, he states something like, what's the dropout rate here, 50%? So it's not just me. I'm not trying to trash talk the school district. Even the judge trash talks it on the bench, on the record, and you guys are going to see that because this is going to go to a hearing. I do feel bad about saying that, but I don't feel bad about saying that I wanted to get my son into a better school if possible, and I did succeed at doing that, but it was very difficult. My ex fought me tooth and nail, and what's weird about the way she fought me is she didn't really pick it up until I had filed a motion. And I think she was, in hindsight, I think she was strategically doing this. At the time, I probably thought she just didn't care. I probably thought she just emotionally checked out. But looking back, I have often referred to this type of conflict as the Cold War, and it is something that is actually very, very common. Two high conflict exes, well, a high conflict case, usually involving a high conflict party, not both parties. Typically, there is a conflict at some point when the child needs to get into school, and rather than grapple it, head on, what happens a lot of times is that there's this weird kind of Cold War where either one side won't talk about it or both sides won't. And then all of a sudden, one side will just enroll the child into school, and the other side will enroll the child into the other school, and then one side will yank the child out of that school. This is not that uncommon. I think it's a lot more common for this weird sort of Cold War to occur than for it to go straight into litigation. And that's just based off of all the emails I get and some of my observations as well. And in my own case, looking back in hindsight, I will explain why I think she was doing that. When I was sending her emails, she wasn't responding to them at all. And what's crazy is, as soon as I got him into the school and I filed a motion, I think she freaked out because she realized that her plan wasn't going to work out. And so she went from not caring at all to suddenly having all of these ideas. She filed an opposition. It contained all kinds of details. We were sent to mediation. She brought like multiple different binders full of all of this information as to why our son should go into one of the public schools. It was the strangest thing ever for her to go from radio silence to ballistic in just a tiny amount of time, and it all happened after I filed a motion. And this is one of the reasons why I warn people about this. If you are with a high conflict ex, don't wait until the last minute to file a motion and think that the court's going to take your side. Oftentimes, the court doesn't have enough time to figure out what to do with it. By the time you get into court, the child's already been yanked out of the school you put him in and put into the school that the high conflict ex put him in. And a lot of times, the protective parent doesn't want to do the same thing back because it's not about yanking a toy back and forth. It's about a child who's going to suffer every time they're forcibly withdrawn from a school and put into another school. Not to mention the fact that the school districts will not tolerate it. At some point, they won't allow it. So anyway, I did suspect that this was going to become an issue. I did suspect that if I enrolled him into a school, she would immediately withdraw him, take him out of the school, and put him in another one, just to spite me, just because that's the way she was. So I had already been planning well in advance to file a motion because I wanted this to go to court as soon as possible so that it can get resolved. At this point in time, I did have the insight to know that the only thing that was going to really work out for our son was court intervention, and it did work in the end, but it was very, very difficult and very stressful. It honestly surprised me just how much he fought me on this. I did actually get my first attorney. It was a friend that I worked with at the collection agency, and he actually represented the collection agency in civil actions. And I asked him to help me out with this, and he said he would if I pulled some weeds. So I straight up went to his house and pulled some weeds for him. It took about 2 days of work, manual labor, but he did come to court. He did represent me. He won the case, and I do have some criticisms about his performance, but at the same time, I got free representation, and it's kind of like, sure, he wasn't perfect, he wasn't great, but he won, and he did good enough, I guess you could say. And I guess it's not just criticism really about him, but it's also criticism towards the judge. The problem that I had with the judge, I mean, there's a lot of problems with the judge's approach to this hearing. I did end up winning in the end, but you know, I think this might be one of the best things to sort of set aside and wait until we actually get to the hearing video, because that's when you guys are going to actually get to see sort of what I have a complaint about with regards to the judge. And I guess in a way, my complaints towards the judge are closely linked to my complaints with my attorney. But this attorney just represented me for this hearing only. He didn't file any of these documents. He appeared at the hearing. He just represented me at the hearing, and that was it. He withdrew. And I'm kind of glad, and it's, again, nothing personal against him. It's just that he wasn't really the ideal attorney to deal with high conflict X. He was the attorney who was perfect for getting my son into a great school, and that was it. And I have this problem again with another attorney, and again, another friend, wonderful person, but not great for high conflict cases. And it's just, they're tough. The cases are tough, and they are the solutions to the problems in these cases are very counterintuitive. They are not at all obvious, and for those reasons, I don't blame either of these two attorneys. They were both friends. One of them is still a good friend, and you're going to see that one in court at least twice. And again, it's better to talk about what's going on, what I have to complain about when I actually get to those hearings. So I'm going to stop at this point, but I am going to mention that I was actually hoping that my ex would agree wholeheartedly with not only the change of the school, but also the change of the midnight exchanges. You guys have heard me talk about the midnight exchanges over and over again. You guys have seen me file documents trying to change the midnight exchanges and failing. You've seen me bring it up in open court and the judge not doing anything about it. And here we are again, trying to deal with the 2 midnight exchanges. Now, a lot of people might wonder, why didn't I try to wipe out the exchanges? My answer to that is because I tried over and over again and it never worked. So I needed a different approach. And my approach was an approach that would defeat res judicata, which is that there needs to be a change of circumstances. Now, under these, you know, he's going into school. That's a change of circumstances. Midnight exchanges for a child who is not going to school is one thing, which I still strongly agree with. But midnight exchanges for a child who is going to school is reprehensible. So my argument was that at least on the school day, we need to end that exchange. And not only that, but we need to actually cut out, you know, one entire exchange altogether to reduce the conflict. And that's the approach that I took because I thought that's the approach that would work. It's not that I thought that was the best approach, but it's the approach that I thought that the court would accept. In hindsight, should I have done that? No. I should have went ahead and tried to obliterate the midnight exchanges again. And in hindsight, knowing what I know now about filing appeals, I probably would have filed an appeal if he refused to do so anyway. In fact, knowing what I know now, I probably would have filed an appeal to the last time that he refused to change the midnight exchanges. I really would have. But at the time, I did not understand the power of the appeal. I have begun to file them. I think I've at this point lost one. And if not, it's going to happen very soon. But I still haven't won an appeal, so I still haven't really figured out the power behind the appeal. I'm kind of testing the waters. So I think at this point, we should just go ahead and take a look at what I have filed. Here we have the motion to modify timeshare and establish education. And what I mean by that is most likely to select the school that our son's going to go to. And I'm identifying myself in the first paragraph, and I'm indicating to the court that I am appearing in proper person, which means I'm representing myself. The motion is being clearly stated, and going into the factual background. The first fact that I am asserting is kind of a summary, standard summary that I sort of start to put at the introduction of any of my court filings. And that states that I'm the father, she's the mother, we share a common child of age 4. Next fact that is asserted is that we share joint physical and legal custody, and that pursuant to the, I guess, current order, I have custody from 3, or visitation from 3 to midnight, and again from 3 to midnight. So twice a week, there's 2 midnight exchanges. Next fact that is asserted is that we agreed to a court order that stated that we needed to modify the schedule by the 3rd week of August 2011. I prompted my ex for some ideas, and she either didn't respond or the requests for some kind of agreement failed. One of the two. I'm sure there's some exhibits at the bottom of this motion that we'll be able to take a look at. Next fact that is asserted is that I advised my ex of my intent to place Army in a school, in the charter school. Oh, that's right, and it requires a lottery. I placed him in the selection process at Montessori and Cornell Academy of Science. I advised my ex of my plans, both my plans and the orientation. She did not appear at the orientation. My next assertion is that I tried once more to communicate with her without success. My next assertion is that I informed her that he was selected and that I had 1 week to enroll him. I made a final attempt to discover if she had any proposed alternatives. She did not respond, and I enrolled him in school. My argument in support of the modification of timeshare is pursuant to the current stipulation and court order. On the 3rd week of May, we need to, when he enters kindergarten, agree to change the timeshare. And the goal here is to get rid of the midnight exchanges. Let's see here. Argument. So, there was an argument up top too for the modification of timeshare. The next argument is the timeshare proposal, a specific one that I'm going to recommend. I cite to a statute and Mac v. Ashlock, which states that the best interest of the child is the sole consideration of the court. In determining the new timeshare schedule, I am arguing that it's in his best interest to warrant the following considerations in order of priority from highest to lowest. First, the schedule's appropriateness regarding his lifestyle and educational responsibilities. Minimizing how drastic of a change the proposed plan is from the existing plan, reducing the timeshare disparity between the parties rather than expanding it, which is true, because I think I had 40%, she had 60%, so we shouldn't expand that. If anything, we should keep it the same or reduce it. And our lifestyle and extracurricular responsibilities. Considering these factors, I am proposing modifying the existing timeshare by simply closing the gap from Friday midnight to Friday at 3 p.m. This was something that I thought would be easy to do, and as I mentioned earlier in this video, it was not. She fought tooth and nail to keep that gap open. This resolves the issue of him having to be disturbed and woken at midnight. It's a minimal change in the existing timeshare schedule, which it is, because pretty much the entire schedule remains intact with the exception of that one hole in the middle of those 2 weekly exchanges. And it reduces the disparity from 60-40 to 50-50. It's like the perfect solution. And I also included an illustration, apparently. Next argument is in support of education at Cornell Academy of Science. When parents cannot agree on the subject of education, the parties come together on equal footing, and the court makes a decision, which is true. My ex has not presented her opinions and alternatives regarding his education, and so I'm left with nothing to compare and contrast with. Because she has, acted in bad faith. Wait a minute, am I saying not so much a clear and intentional act in bad faith as a lack of enthusiasm? Well, in hindsight, I think it was intentional. But, I mean, you could look at this in the vein of, at best, it's a lack of enthusiasm, and at worst, it's intentional. Kind of a common phrase that people mention. I did my due diligence to keep her informed over and over again, and she had numerous opportunities to express an alternative and did not do so. Now, I'm not going to talk about this again because I talked about it earlier in the video, so I'll just continue on. Hearing. I'm not requesting a hearing in this matter, and if she proposes an alternative and the court wishes to hear testimony comparing the schools, I'm advising the court to set a hearing promptly. And I would like his education to be at Coral on August 9th, 2011, as the classes start early. Otherwise, there does not appear to be an absence of genuine issues of material fact. And that's the key statement there. I mean, without an alternative proposed, there's no genuine issue for the court to consider. I just want an order to be mailed to me. But I am mentioning, should she file an opposition and that create some kind of genuine issue of material fact, then of course I concede we're going to have an evidentiary hearing. Conclusion. I am requesting that the court modify the timeshare basically by closing that midnight gap. So we're still going to have a midnight on Sunday, but we're not going to have 2 midnights a week. We're going to go from 2 to 1. And the court order the parties to accept Coral as a school, and that's it. Here's my affidavit, which is required according to the court rules. Each and every motion or opposition filed, I think replies to, I'm pretty sure replies to, filed by parties have to be verified by a sworn affidavit. Affirmation, which we've seen 100 times by now at least, and this is just indicating to the court that I have reviewed the document and I have verified it does not contain a social security number. And this is the standard motion opposition notice. This is the notice that you go through, read the instructions, check the boxes, and determine whether or not you have to pay a filing fee. I believe here I have reached the conclusion that I do not have to pay one. You know what though? I still question whether I got these right. It was hard to tell, especially not knowing what a modification of an existing order is. And I think I felt a lot of times I was just adding to an order and that I wasn't really changing an order. But I think, well, hold on a second here. Has the final decree been entered? Yes. Is this a motion to change a final order? No. See, I think this would have been a yes, but I'm not sure. To this day, I'm not fully sure what they mean by a modification or just another order that's being added. List of exhibits. We've got 6 different exhibits. Stipulation and order, which I'll probably skip over since we've already gone over that. Illustration, a couple of 3 emails, and the acceptance letter from the school. So we've got a few exhibits to go through here. Exhibit 1. Now this is a stipulation and order that we've already agreed to. This is the order that discusses what to do when we show up late, apparently. And I must have overlooked that portion of the order. But again, when I go through a document that I've already covered in the My Docket series, I skip it. And of course, you can always go down into the description below, click on the link, download the document, and read the exhibit for yourself. But if you've been following the series in order from beginning to end, you would have already gone over this document anyway. Exhibit 2. Here is the proposed timeshare. So as you can see, the existing timeshare is on the top, and there are 2 blocks of time here that I have. She has the unshaded areas, I have the shaded areas, and then there's this gap right here in the middle. And there are there's 2 midnight exchanges, one of them over here and one of them over here. And all I am proposing is that we keep the exact same pickup and drop off with the exception of this gap here. This gap, I'm proposing that we eliminate it and that I just get to have that chunk of time as well. Exhibit 3, we have an appointment with Shirley. Let's see, this is from me to her. No, you haven't met Stephanie yet, bringing her to the next pickup. Opportunity to meet her. Where's the school stuff? Current sitter, not bickering about court orders. Threatening to file a motion if she violates a court order. I don't see anything in here about school. Oh, here's the parent orientation. So I'm mentioning to her that there's an orientation to go to. And again, guys, I try to not spend a lot of time on these because it's just, most of these emails are full of inane content, stuff that doesn't really factor into the case. And if you want to learn more about what I believe with regards to communicating in messages like this, please take a look at the video Communication. And I think I have another video. Failing to agree covers a lot of the dynamics behind dealing with a high conflict X, but communication and failing to agree, please take a look at those videos. All I really want to point out here is that I mentioned to her there's a parent orientation and I gave her the specific date so that she has an opportunity to go. Exhibit 4 is probably her response. No, this is another email from me to her. Let's see. Learning Center, I don't know what that means. Do you want to work out his new timeshare or should I go straight to Kathy? Saves you money if I don't have to go through her. Okay, again, so we're trying to work out the new timeshare. Exhibit 5, we've got another email. Okay, so all 3 of these were sent to her. We've got no responses from her to me, at least not at this juncture. And I'm telling her that I got them into Coral. So it looks like this is basically me expressing to the court that I'm sending her messages about the new school that I'm trying to get them into, and she's not responding at all. Exhibit 6, here we have, it looks like the acceptance letter. Or is this the application? It's one of the 2. I see the acceptance. It seems like an acceptance letter here. And here's the letter. Okay, so the upper section must have been what I used to get him into the school, and the lower section here is why do I want him to be enrolled, uniform checklist, registration checklist. So this must have been all the stuff that they sent me. Looks like it. The location of the school and a map. A receipt. So this is me paying. Okay, yeah, this is me paying that fee. It's like they call it a tuition fee, but it's actually I don't know if they call it that. I think it's called a tuition fee, but it might actually be a supplies fee. In any event, that last exhibit is apparently proof that he got into the school, and he did get into the school. Here we have the certificate of personal service. Again, this is a document that can be just included. Well, you don't even need to put the whole document. You could just take this section alone and just include it in the motion or whatever it is that you're filing, put it at sort of the bottom, the last page, whatever you want to call it, and that would be good enough. But I have filed it as a separate document, which is okay. You can do it. It's just typically not something that an attorney will do. Anyway, I'm indicating to the court that on the 5th of May, I personally served the motion to modify and the notice of urgency upon my ex's attorney. We're actually going to go over this notice in a second. But anyway, this is personal service, and so what that means is I physically went to my ex's attorney's law office and physically gave the stack of papers to one of her employees. Here we have another affirmation, which we just talked about. And here we have the notice of urgency and time limit to respond. This isn't really something that should have been filed. I understand what I was trying to do. I was really trying to underline the importance of getting this resolved quickly. I'm mentioning to the court that he starts school on August 9th. I'm mentioning to the court that DCR 13.3 requires a response within 10 days. I wonder when this was filed. May 5th. Let me check the other document really quick. May 5th, so same day. So it's not even like I waited. I immediately filed a notice of urgency, and I wanted to make it clear to my ex that she had 10 days to file a response. I was not playing around here. If she didn't file a response, I was going to push for an order because her child had to get into school. You know what? This is actually not soon enough. May, June, July, August, that's 3 months. I guess it's okay. I would recommend 6 months though for any of my viewers. The reason why is you might lose and need to file an appeal. So 3 months in advance is okay, but push for 6 months in advance. And anyway, this is a local rule here that states that if an opposition isn't filed within this amount of time, that the court can just assume that the motion that I filed has merit, and the court can, based on that assumption, grant the relief that I'm requesting. Again, in hindsight, don't file this. It's just an extra document. Who knows if the court's even going to read it? And if you really want to stress that something is urgent, just include some language in the beginning of the motion itself and mention right off the bat this is urgent. You don't have to file a separate document. Another affidavit, I don't know why. I guess I'm just backing up the fact that what I am stating is under penalty of perjury. Going into the aftermath, I filed 3 documents, but they were all free filings, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney at this point in time, so I incurred $0 in attorney fees. My ex's attorney, let's see here, notice of urgency and the certificate, she would have probably spent 5 minutes for both of those combined. The motion to modify is tricky. I would say 10 minutes, which would take her to 15. Probably to just review it. It's not that complex of a motion. It's a pretty standard motion with regards to trying to get a school choice or trying to get the court to order a school out of one or both parents' choices. And so that would have us at 15 minutes, but I think I should include another 15 minutes in communication between my attorney and my ex. My ex's attorney and her ex. She would have probably at least spoken to my ex a little bit on the phone about this. I'm going to put more time into that when we actually get to our opposition. But at least 15 minutes, I think, sounds reasonable. Conservative and yes, but still reasonable for my ex's attorney to communicate with her client on the motion that I have filed. So that's 15 additional minutes, which takes it to 30 minutes. At the rate of $250 an hour, that comes to $125 in attorney fees. As with my previous videos, if you have any questions, feel free to post them down in the comments below. And I will see you guys next time.